question. So, Senator Roberts, please.
Thank you, Chair. What has Coal LSL done since last Senate estimates to address the errors and wrongs identified in employer data? And when will people be compensated? And what is the total value of the errors to date?
Thank you, Senator. Darlene Perk, CEO of Coal LSL. So since the last Senate estimates in March, the focus of the organisation has been on getting visibility of the issues that were identified. The 6 individuals who were addressed in the October Senate estimate have had their records updated, which resulted in a change of 55 hours of entitlement for the 6 in total. The other 2 individuals of the 8 haven't resulted in a change in their record on that review. Now, in saying that, work that's commenced outside of those 6 individuals has been a commitment by Coal LSL to commence an audit of employer data for any employers who do have casual employees within the Coal LSL scheme. That audit has commenced and is in train. We don't have visibility yet of what the outcome of the audit will be or any changes to individuals' records as a result of that audit.
Thank you. Second question, why doesn't a casual get the same Coal LSL payout as a permanent employee when they both work the same hours and roster on the same site in the same role? If this is because of the Act, why hasn't Coal LSL referred the matter to the government, and why hasn't the government fixed this?
Senator, if a casual employee works a 35-hour week, which is a full-time equivalent, they will accrue the same long service leave entitlement as a full-timer. So our records for the employee are held in hours, and if the employee does work the 35 hours during the week, their record will be at that full-time equivalent maximum entitlement.
Thank you. Are casuals made aware that they can waive the Coal LSL scheme and have the contribution paid direct to them? As you will appreciate, this would benefit a lot of casuals that may not stay for the 8-year qualifying period.
Senator, I can't talk to whether casuals in particular have visibility of that. That was an enhancement in our legislation back in 2010 to include waiver agreements as an option for all employees in the scheme. I can take that question on notice, but from memory we have as minimal as 4 waiver agreements, but I will verify that number and confirm that.
Sorry, what was that last sentence you said?
From memory, I think we have 4 waiver agreements in place out of 426,000 records, but I will take that question on notice and verify that.
Why, if a casual does take the Coal LSL waiver option, do casuals only get paid 2% when the Coal LSL payout is based upon 2.7%?
All employees, irrespective of their employment status, Senator, will be paid based on certain criteria in the legislation, which my colleague Mr Kembry will talk to. But the 2% you're talking to is our payroll levy and is not correlated to an employee's long service leave entitlement. That percentage is in relation to the payroll levy that employers are required to pay. It is a tax that's imposed, and that levy of 2% has been in place since 2018. Prior to that, it was 2.7%, but it was reduced back in 2017 to that lower level, and is a rate that's applicable to all employers who are registered in the fund.
Thank you. Could you please provide details on the number of casual employees who have contributions made to the scheme for them, and detail how they may have been paid out? How many left the industry, and how much money this represents for those employees who have not returned to the industry in, say, over 3 years? In other words, they haven't been paid out and they've left the industry.
Senator, I could talk to the amount of casuals who are active in the industry today. According to our records, it's round figures 9,000. I will need to take your other questions on notice. They are quite detailed questions that will need to be responded to.
Yeah, that's fine if you take them on notice. They are very important to us. Next question. Can you explain in detail, please, why the amounts contributed by employers to Coal LSL for eligible employees, both permanent and casual, are different to the amounts paid out for those employees? And could you please explain the reasons for the discrepancy in detail and the breakup of what funds go where and the total value this represents annually?
Senator, there's two important components of the fund. The payroll levy, which is a tax that's collected on behalf of the government. Now that is received monthly by employers. It is appropriated to the Commonwealth, remitted to the Commonwealth and appropriated back. Separate to that is the records that we hold for all employees in the fund, and that entitlement is accrued in hours. The payment that's made to the employee will be reliant on their employment agreement. Our legislation does specify the minimum that should be paid. Mr. Camry might be able to refer us to the section in the legislation that talks about minimum payment that's required on termination or in-service leave, but it is a different, part of the legislation to the Payroll Levy Collection Act, which talks about levies that are received for the fund.
Thank you. Is Mr. Camry going to add anything?
Senator, in Peter Camry here, General Manager Legal with the Coal LSL. I think the question really, the best way to break it down is that the payment of levy is not necessarily correlated to the accrual of the entitlement. And when entitlements are paid, they are paid at the rate the employee is earning at the time that they take that long service leave.
Okay, thank you. Can you please reconcile the difference between employer contributions and employee payouts? And please also advise what happens to, firstly, the funds where an employee leaves the industry prior to qualifying and fails to return to the industry, and secondly, the total amount of these funds where employees have left the industry and how much is dispersed and to whom on an annual basis over the last 7 years.
Senator Darlene Perks, the fund is a pooled fund. It's important employees in the fund understand we're very different to a financial institution and super funds. The fund is a pooled fund. The nature of portable long service leave means employees can move in and out of the industry and they can have a maximum break from the industry of 8 years before their qualifying service accrual is impacted. So that's important context. We must hold the funds for that period of break service of 8 years in case that employee returns into the industry so that we can continue to ensure that we have sufficient funds to pay out a future long service leave. The actuary assesses and projects the fund's assets and liabilities based on important assumptions, one being investment returns, but also the probability of employees reaching 8 years of qualifying service. Now, in regards to the employees that you're talking about, the probabilities of an employee meeting that 8 years of qualifying service starts at a base of 50%. So our history tells us, or our data tells us, that an employee that's been in the industry for less than 1 year has a 49% chance of meeting that 8 years of qualifying service. So we hold the funds as a pooled fund through that duration of a maximum of 8 years break period to anticipate that future liability that the fund may incur. So it is a complex calculation that the actuary conducts that has fundamental assumptions that underpin that assessment of the fund's assets and liabilities.
Could you please tell us then how much money is involved in people who've gone beyond the 8 years and are not in the industry and won't ever get a payout, and what happens to their money?
Sorry, Senator, can you ask that question again, please?
If someone leaves the industry and a period of 8 years lapses, what happens to their money?
So, Senator, the fund is structured as a pooled fund. So employers pay a tax to the government that is appropriated back to the fund. The actuary assesses assets and liabilities. So we hold an entitlement in hours for the employee. We do not hold an asset which is financially attributed to that individual record. So it is, I'm being, I guess, specific, but the record doesn't have a monetary dollar correlated to it at the record level. It is reported in hours. We assess, or the actuary assesses, based on the hours that we hold, and there's 55 million hours of entitlements that were held at June 2020. The actuary assesses the likelihood of paying liabilities out of the fund based on the entitlements that are held in hours.
So you would still have to account for everything in a dollar sense if it's a pooled fund, wouldn't you? Because some people are not going to come back after 8 years. So what happens to that money? What happens to those hours? Where do they end up?
So, Senator, if an employee has a break from the industry for 8 years or further, their record will cease to accrue, and if they return to the industry, they would start from 0 years of qualifying service again. So 8 years break, which is the most generous break that any long service leave provision allows for. Now, in that record says the actuary assesses the likelihood of someone returning to the industry. And in that assessment, the actuary says, the fund needs X dollars to pay out future liabilities. And with that correlates a payroll levy that is appropriate to be imposed on the employers in regards to the collection of future levies. So in the situation where if we've seen a larger number of employees not returning to the fund, one would assume that could result in the pooled fund increasing, the liabilities would decrease, and if our assets are in excess, that could result in us recommending to the Minister to reduce that payroll levy further from that 2% to a lower rate. So the assets and liabilities are correlated continuously by the actuary to assess whether the payroll levy is sufficient, that's imposed on employers, to meet the liabilities that are projected to be, incurred by the fund in the future.
So are you saying then, just checking my understanding, that if someone is out of the industry for more than 8 years, if they come back after that, they will go back to 0 to start again, and that if there's a surplus in or an excess of funds in the fund, then in the pooled fund, then the Minister will have a recommendation to reduce the payroll levy?
That is in a simplified manner, yes. The three correlate, yes.
Thank you. In 2019, I drew to your attention discrepancies and outright employer misreporting. What have you done to fix all employee entitlements? What steps has Coal LSL taken? And if this response took the form of a review project, when will the project be completed and how much will the project have cost? And will Coal LSL be prosecuting employers who have negligently or willfully misreported or mispaid Coal LSL contributions?
Senator, the important action that Coal LSL has taken since March is to commence an audit of employers of casuals, and that is, it said, 9,000 casuals are active in the industry today, so that audit program will extend to review those records. That is in train. The outcomes of that audit will be assessed and certainly will be reviewed as to whether rectification or penalties would be appropriate if there's any understanding of deliberate misreporting of hours.
You have the ability to penalise employers, right? And prosecute them?
Yes, Senator, in certain circumstances that is correct. I mean, in terms of the timelines in regard to this, it will be a rolling timeline, I would, and potentially that we're in the early stages of this. We'd expect to see some results to the audit in the next month or two, and then that rolling out over the next 12 months.
Thank you. If Coal LSL is not prosecuting any parties for negligent or willful misreporting, could you please advise the assessment process that Coal LSL went through, how this assessment process was managed, by whom, and also explain in detail despite the evidence of misreporting, why no parties were held to account. You won't be able to do that for another month at least, but could you be able to do that, please?
Certainly, we can take that on notice, Senator.
Thank you. Could you please report whether any members of the Minerals Council of New South Wales were parties or related entities to those who misreported, and provide a list of same, including the number of instances by entity? That, you know, if you take that on notice as well, because that won't be able to be done at least for a month.
Yes, Senator.
Thank you. Look, I've also got concerns, as we've spoken about in the past, with regard to the governance of Coal LSL. So I'd like some data, please. Could you please provide an Excel spreadsheet including all employers registered with Coal LSL covering the period 1 July 2012 to 30th of June 2020, including the company or business name, their ABN, the authorised officers, active dates, details of payments or reimbursements made to each registered employer for the subject period?
Senator, that would be an extensive task. Potentially we could discuss what it is that the information we'd like from that, because over an 8-year period, and when you say authorised officers, I'm assuming you're meaning directors?
Yes, the people you're dealing with, yes.
So often we're not dealing directly with directors, we're dealing with employees of the company, so that would mean, Senator, perhaps if we take this question on notice and we can talk further about how we could present the material that you're after.
That'd be great, thank you. Could you also please provide details of the process used to calculate payments to entitled employees? That is, how the amounts received, the entitlement, and other costs or inputs or outputs are calculated. I'd like to understand the process.
Senator, we can provide, we'll take that question on notice. We can certainly give more context to the payroll levy collection, the calculation of the entitlement, and then the employer reimbursement rules that relate to the outflows. Thank
you. Can you please provide details of where Coal LSL funds received for workers who leave the coal industry are held at all material times? And I know you talked about them being in hours. Who has the records and the details of the process following the cessation of contributions for employers? Where, could you just tell us where the hours or money goes? Could you also please include full details of where these funds are ultimately repatriated and full details of any service fees, costs or commissions are paid and who they are paid to?
We can take that on notice, but Senator, I can say there is no commission service fees in regards to payments. We will take that question on notice.
Thank you. Could you please provide an Excel spreadsheet of all entities that Coal LSL pays or transfers funds to, including but not limited to company or business name, ABN, authorised officers, dates and details of payments or reimbursements made to each entity, including total payments, and an explanation of as to the payment, for example, fees, etc.?
Senator, is that in relation to the employers in the fund, or are you talking more broadly of every transaction that the fund incurs?
No, just the payments made to people who are entitled to have Coal LSL.
Okay. We'll take that on notice, Senator. Yes, we'll take that on notice.
Thank you. I'm led to believe that registered employers have great difficulty in reconciling the payments made to entitled employees by Coal LSL, as they don't seem to correlate to the employer contributions. Could you please detail the reasons for any differences between employer contributions and the total amounts paid to eligible employees? And in this regard, please advise where unallocated, surplus or remaining funds or hours are allocated, and please advise whether this allocation complies with your constitution and governance framework. Have these matters been raised in any internal or external audit over the period 1 July 2012 to 30th of June 2020?
Senator, that question, the first part of the question, I'm taking as being similar to a previous question, so we'll answer that in light of the previous question. Coal LSL is audited by the Australian National Audit Office annually. The audit has been completed. There are no findings in the audit. And we've had no findings in our audit for the last 2 years. So we can give you a copy of that audit report. It is included in our annual report, which is going through the tabling process currently. So that is available for public review.
Okay.
Senator, I note in that question was about 5 questions, so we'll take a number of those later ones on notice. But the first point you raised was in regard to employers struggling to correlate the reimbursement to the payment to employees. Is that correct?
Yes, that's correct.
So the matter of what is paid to an employee is a matter that is to be decided between the employer and the employee. And then the employer requests a reimbursement for that payment, and that payment we need to see some evidence that the money that they are requesting from the fund was paid to the employee. And the reimbursement needs to correlate, but there needs to be some correlation between the levy payment that they're paying. So in a sense that the salary or the payment, the wages that they're paying levy on, so we can ensure that they're either not being over-reimbursed or that the employee isn't receiving, certainly not receiving the reimbursement in full. So that's where the correlation should be. Without any specifics, Senator, it's difficult for me to talk to.
Okay, we might be in touch with you then, more on that. I've raised many concerns in regard to the treatment and payment of Mr. Simon Turner. I note that you're aware Mr. Turner was forced to leave the coal mining industry due to workplace injuries at Mount Arthur Coal Mine that left him totally and permanently disabled, TPD. I note that approximately 3 years after my raising these injustices and Senate estimates, Mr. Turner has had his case only partly reviewed, and that Chandler McLeod, his employer, and Coal LSL have yet to resolve his termination status as being TPD. When will this status be updated, and when will Mr. Turner's outstanding questions be addressed?
So, Senator, as we discussed back in the estimates in March, we have been assisting Mr. Turner for a number of years now, and the difficulty with the particular issue you're raising is that is a dispute between Chandler McLeod and Mr. Turner. We have been trying to mediate that and obtain some factual evidence to support the position put forward by Chandler McLeod. At this point in time, the parties are holding their position and they don't agree with each other, and the last we were advised that those matters are subject to court proceedings in the federal court at present. So there is not anything more we can do to try to resolve that, unfortunately.
What sort of records would you turn to for proof?
So we would turn to correspondence, contemporaneous correspondence that evidences the reasons. As you know, Senator, this is a dispute about the reason why Mr. Turner was terminated from by Chandler McLeod back in 2016. So we have requested contemporaneous material that supports the position that Chandler McLeod put forward or justifies that position. And that has been provided. Now, whether we're not in a position to make a legal assessment of that, because that is not our role. The Fair Work Commission has the power to do that, but I believe there were Fair Work Commission proceedings on foot, and those proceedings have been transferred to the federal court. So, look, hopefully, Mr. Turner, there is some resolution to that matter in the near future.
Senator Roberts, just before the next question, we will be breaking at 3:45 for the afternoon tea break. And concluding with these witnesses, and I know that Senator O'Neill does have some questions, so if the two of you could perhaps have a conversation about timing for the remaining 9 minutes, that would be fantastic.
Okay, we've got 4 more questions that I'll put on notice to you, Mr. Kembury and Ms. Perks, but I'll ask this question. Queensland and Hunter Valley coal miners and coal miners everywhere expect Coal LSL to maintain a high standard of probity. Casual coal miners expect that you will do the right thing by them and give them the freedom of choice to waive the Coal LSL contributions and for them to receive the 2.7% or, if 2%, additional income. So, as additional income. So I just want to make that point on the record. So thank you, Mr. Chair.